party
Thank
at
you,
this
Judge.
point.
Judge, just to clarify, the contempt actions that we filed previously, those have been dealt with. So the only thing that's before the court is basically the final hearing, the establishment of parenting plan. And so I'm hoping that it will not take very long today. And so just a brief procedural history, since this case has been going on since last year. As you've stated, Judge, back in March of 2024, my client has filed a petition for paternity in response to a child support action that was filed against him, where he was ordered to pay $800 per month. In May of 2024, he was confirmed as a biological father following a DNA testing. And then in July 8 of 2024, he filed a motion for a temporary parenting plan on the basis that Ms. Hewitt was not being cooperative with visitation time with him. And that was heard August 31st of 2024, where Your Honor ordered supervision at the mother's home. And I believe that this was largely based on the fact that the mother claimed that the child had medical issues, heart conditions, nonverbal autism, and things of that nature. And so you were not comfortable with father having unsupervised visitation at that point. And so father attempted to have visitation from August 31 all the way to November 19 when I was hired in this case. From August to November, father had difficulties with this supervised visitation, resulting in us filing for contempt actions and motion for Christmas visitation. That was heard November 19, and Your Honor did allow my client to have unsupervised visitation overnight. That was for the Christmas time, but kept the same visitation for my client. And that day also, the mother maintained all of her claims that the child had some rare condition. He was going to therapy throughout the week. He was getting speech, OT, ADA, physical therapy. And so based on that, again, my client stayed in that same visitation. And so then we fast forward to January 29. At that time, I had subpoenaed all of the medical records and the TEIS, the Tennessee Early Intervention records, and the school records. And we had a hearing January 29, resulting from our motion to appoint my client as a temporary parent, primary residential parent. At that point, we were so concerned of what we found. And in that hearing, Judge, you did found that Mrs. Hewitt had delayed access to certain services with TEIS for about a year: physical therapy, speech therapy, developmental therapy. There was an ophthalmology consult that was not done for months. Ashton had a cardiology appointment that was not done, well baby checkup, and that's in the order, Judge. And so at that point, Your Honor did not find that Ms. Hewitt was credible in her testimony, and you appointed my client as the temporary primary residential parent, and then awarded Ms. Hewitt a weekend visitation, and the child support was suspended at that time. February 25 of 2025 of this year, Ms. Hewitt then hired an attorney. We had to file a second criminal contempt because at that point, your order was for Ms. Hewitt to return the child after her visitation to Mr. Fenton. And by May 14 of 2025, you heard two motions, actually three motions, all of my contempt motions, and Ms. Hewitt's motion to reconsider the January 29, 2025 motion. You denied that motion to reconsider, And then you found Ms. Hewitt guilty of 2 counts of criminal contempt, specifically. That was 2 days in February where she refused to return the child. And you had suspended the 20 days of incarceration at that point. And then you also, Judge, modified the pickup time from 4 p.m. And my client was supposed to pick up, so that way we prevent, further issues. And then also on that day, we were supposed to be heard on this motion for the permanent parenting plan, but because Your Honor was considering the fact that the lawyer was just hired that time, that you were giving him some time to get acclimated with the case, you continued that, and then here we are today. And so, Judge, our goal is to finalize this case and finalize the parenting plan. And also, Ms. Hewitt, obviously, his lawyer had withdrawn by July of 2025. It's been well over the 30-day period that you gave her, so she hasn't hired a lawyer, obviously. We had filed a proposed permanent parenting plan initially, but that has now changed, and so I am going to present an amended one just based on the recent events that happened in the interim from May when we were here to today. The proof will show that Ashton, he's 4 years old now, he's done tremendously in a good way. He's gone to school, he's updated with all of his medical needs. He has been adding to his vocabulary, which is great. He's gaining friends, he's very close with his teachers. He's just overall has become healthier. His eating habits are better. And so it's been great for this child since father has taken over the overall decision-making. In contrast, Judge, mother continues to engage in hostile communication with my client. She's making derogatory comments. So mother's visit started February 7 of 2025, every other weekend. So she would have had 15 weekends from that time. Out of the 15 weekends that she was awarded, she only exercised 5. Out of that 5, the last day, she had only exercised 1 overnight because the following day, the children had to be taken to the grandfather's home. The DCS was involved, police was involved, and we'll get to that. So we have the police officer as well, subpoenaed to testify. The very first weekend that mother exercised her visitation on February 7, that was when you found her guilty of contempt because she refused to return the child to the father. February 21 was the second instance of her visitation, the same situation. Refused to return, and my client had to drive 1.5 hours to Tennessee to pick up. And so that was another contempt finding. And then she visited May 30. She was late, but my client accommodated. It was supposed to be 4 p.m., but she came at 6:30. And then the next one was June 13, and then the last episode was August 8. And August 8 was the day when the DCS and the police were involved in the situation. The proof will show that August the 9th, Saturday, the Department of Children's Services were called. There was an anonymous call put in. Apparently, Sophie, the 12-year-old, who is the other daughter of Ms. Hewitt, had made some complaints of abuse. There was some Adderall situation there that will come out in the proof. The environment itself the house was unkept, and we will have photos to show of that. There was some environmental neglect allegations. And so it resulted in the children being taken to the grandpa's home. And then my client got a call from the police department, Dixon Police Department, asking him to pick up the child. And so my client had to drive again. He was on vacation at that time on a Saturday to pick up his child. So the visitation was cut short. All throughout, from February to today, mom has never checked on the child, never sends any message to dad what's going on with Ashton. Maybe she doesn't have a ride to pick up, but doesn't even initiate any video calls whatsoever. In contrast, my client has been cooperative, bending over backwards to accommodate Ms. Hewitt. And so, Judge, we do have a lot of concern. And the other thing is the diet that's being fed to Ashton. It's going to come out as well in the proof. And so I know that it is very drastic, but in our proposed permanent parenting plan, of course, we were asking that Mr. Fenton remains the PRP with exclusive decision making. He's doing a great job. Our concern is Ashton. If he continues to stay in this environment, the environment is not healthy, and we'll show the photos. And the other things, the situation with Sophie, it appears that Sophie has been tasked to take care of Ashton every time Ashton is there, and mother just does not participate. My client is asking that mother's visitation just occur in the county where he lives right now instead of overnight, unless Ms. Hewitt can show otherwise that she's fit and capable. And we're asking Friday from 5 p.m. to 8 p.m., Saturday and Sunday 8 a.m. to 6 p.m. And these are the same schedule that Mr. Fenton had when he had to come here. So I feel like it's only fair that she gets the same. And we're asking that mother is to pick up and drop off from Mr. Fenton's home. We ask that applies day to day. And then for the summer, my client is asking that he gets at least 2 consecutive weeks for the first and second months of the summer. If the child support is assessed against the mother, which I believe it will when I calculated it, I do not have credible evidence of her, Ms. Hewitt's income, just because I've not received any discovery responses that I propounded, whether she was pro se and whether she was represented. And so we would ask that the income be imputed per the child support regulation. However, Ms. Fenton does acknowledge that Ms. Hewitt will incur travel expenses, and he wants her to see the child. And so he is willing to waive whatever child support, if any, is assessed against Ms. Hewitt. He will provide the insurance. He will continue to do that. And then we're asking that he claims him for the tax purposes. So in summary, Judge, we're asking if we apply the best interest factors here, it's truly unfortunate that we had come to this point. We were hoping that things will get better, but instead it got worse. And so we're asking that when the court applies the best interest, it finds that majority of them favors my client and that he remains the PRP and that no overnight visitations be awarded to Ms. Hewitt at this point. That's what I have, Judge. Thank you.
Ms. Hewitt, you are representing yourself, your prior attorney having withdrawn. You have the right to make an opening statement, but I'm going to give you a chance to testify. Do you want to just reserve what you want to say when you testify?
I would like to get a few things straight.
All right, then come on up to the podium and you can tell me whatever you want. This opening statement is not evidence. The evidence will be presented in the form of testimony, but I'll give you a chance to respond to what Ms. Hendrickson has said.
Ashton was never out of school or, I've got his schoolwork, his attendance, his IEPs, everything, his doctor's appointments. Now, his, cardiologist switched to different companies. So we were in the process of switching from Dr. Bruns's pediatrics cardiology to another one. But I've got all his school, I've got his school pictures. He was getting ABA, physical therapy, occupational therapy, everything, every day. In TEIS from birth, there was never a gap, except when I switched from TEIS to the Dixon County Board of Education. And I mean, there wasn't like a month lapse or a week, or we just switched. I
Now,
don't
you
know.
have your daughter here to she's not going to testify because she's in the courtroom. Why do you have her here to sit in and listen to the testimony that's going to be
I'm not,
presented?
she wanted to come for,
Do you think it's in her best interest for her to listen to the things that you've heard Ms. Hendrickson, what she says that they're going to present? Do you think it's in your daughter's best interest for her to be sitting in here and listening to this?
now I know, no, I don't think it is.
Well, then let's have her step outside and sit in
Yes, sir.
there's a lobby area that's quite comfortable. She'll
Yeah,
be
her
able to sit
cousin's
out
out
there.
there.
All right.
I guess that's all I have to say right now. I don't know what else to do.
All right, let's have a seat. Mr. Fenton bears the burden of showing why he should be the primary residential parent on a permanent basis, so we'll go ahead and let him present his proof. Ms. Hendrickson, you call your first witness.
Fever, yes. Thank you.
Officer, if you'll step right up here, please. Ask you to raise your right hand and be placed under oath. Pull the base of that microphone up towards you there. That base will slide if you can pull the base of it towards you.
I think that's good.
Thank you. Good morning, officer. Would you state your name for the record, please?
Officer Brandon LaPeber, Dixon Police Department.
Okay, so you're employed with the Dixon Police Department, is that right?
Yes, ma'am.
And what is your position there?
Patrol officer.
Okay. And are you familiar with the parties sitting here today?
Yes, ma'am.
Okay. And did you come upon them on August the 9th of this year?
Yes, ma'am.
Okay. And then will you tell the court what was the reason for your, so you had an interaction with which party?
Miss Hewitt.
Okay. And so tell the court why you had an interaction with Miss Hewitt.
On the 9th, we received from dispatch, a complaint and calling in, asking or reporting poor living situation for the children. She asked that we do a welfare check. I spoke to her a little bit, just explained to her what we could do. We could do a welfare check on the child, and she asked that we do that.
Okay. And who had made that call?
As I believe it was if I recall correctly, it was the aunt of the Miss Sophie.
Okay. Okay. And then and what happened next? Did you proceed to check
So
on
we
the
proceeded
home?
to 313 Martin Luther, make contact with Miss Sophie, and I'm not familiar on the other child's name. The little boy that was there with her.
Okay.
we made contact with them outside, and asked if their mother was home. I believe she called her mother on the phone, and then I went inside, spoke with the mother, and Officer Martin stayed outside and spoke with Sophie.
Okay. So when you got there, did you testify that you encountered Sophie and the little boy? Is that right?
Yes, ma'am.
Just
They
the
were
two of
outside.
them?
They were outside, and the little boy was playing in a pool with some bubbles, and mother was inside.
Okay. And then, so did you talk to Sophie, or who did you talk to first?
I talked to mother first,
Okay.
Miss Hewitt.
Okay. And then, so did you go into the house?
Yes, ma'am.
Okay. And what did you observe as you were there in the house?
I've observed clutter, chemicals on the floor, trash on the floor, open baking soda in this bathroom, the middle bathroom, clothes all piled up in the child's room, food. Their kitchen was very dirty. There was canned food in there. I believe there was some snacks and stuff for them to eat. The
You go ahead.
okay. The freezer was stuffed full of just random things, very dirty as well. The fridge didn't have a light in on it. It was barely working, so a lot of their stuff was in the freezer due to the fridge not working. Miss Hewitt reported that she did tell her landlord that, she's having problems,
Okay.
but they had not responded yet.
Okay. You were handed those photos. Are they familiar to you?
Yes, ma'am.
Okay. If you would just go over those, and do they fairly depict what the condition of the home was when you were there?
So they do.
Okay.
The picture of the kitchen that was taken at this point, the mother had already started cleaning up.
Okay.
So
Okay.
it was even worse than
Than
what
those
this picture
pictures.
is, yes.
Okay. And you testify that you saw cleaning materials and chemicals that were
There was
open.
bleach, 409, Ajax, baking soda, everything within a child's reach to get to it.
Okay. And Judge, I would ask to put that in an exhibit, the collective photos.
Recommend as Exhibit 1.
And so in your mind do you have children?
Yes, ma'am.
And as a father in that environment, do you believe that that's safe for a 4-year-old to be in?
No, ma'am, I do not.
Okay. And then, so is there any other observations that you would like to tell the judge as far as the home environment is concerned?
I do believe that DCS does need to get involved inside that home with the other children. And I know we're here about the little boy. But the Miss Sophie reported to us that the mother, every time DCS would come and they would leave, she would abuse her, call her names, and smack her wrist. She ended up grabbing her wrist so hard she has a little cut on her wrist. So
How old was this child?
12. So the initial report was for Sophie, but then we realized that father had primary custody over the son, so we sent him with grandpa, and we convinced mother to let 12-year-old go with grandma as well.
Okay. Is there any issue about maybe drugs and things of that nature? Was that discussed?
So Miss Sophie, the daughter, the 12-year-old, advised that her and Miss Hewitt are prescribed Adderall. I believe Miss Hewitt has a slow releasing Adderall, and Miss Sophie has a fast releasing Adderall. Her mother started abusing her prescription of Adderall. She went back to the doctor, advised him of it, and due to that, the doctor stocked the medication for Adderall for the daughter, according to the daughter's statements.
Okay. And so have you been back into the home after that day that you visited it?
I have not, no
Okay.
ma'am.
All right. And as far as you know, do you know anything about the DCS situation, the case?
I have not followed up with it. I do plan on asking, I think their case manager is Misty.
Okay.
How's it going? But they haven't called me or asked me anything about it.
Okay. And so, but that situation resulted in the two children being moved over to the maternal grandfather. Is that right?
Yes,
Okay.
to his dad, I believe. We requested DCS to come out that day.
Okay.
They did not find it probable to come out, enough reason to come out.
Okay.
So they spoke with Miss Hewitt and they spoke with, and we kind of, Misty, I believe, convinced her to let Miss Sophie go with the boy to their grandfather's.
Okay. So there was enough concern there that you all decided to have the children taken away
Due
from
to the
from
statements
that
of the
home.
child of what she was saying was happening and
Okay.
her emotional state, and then the house condition, I believe that DCS should have came out that day. Yes, ma'am.
Okay. Is there anything else that you would like to tell the court about this situation?
Yeah, ma'am.
That's all the questions I have, Judge.
Ms. Hewitt, you have the right to ask this officer questions, but it must be in a question form. Do you want to ask a question?
No, sir.
All right. Officer, it's my understanding that you contacted DCS, but they decided it was not, for some reason, they did not come out?
Yes, sir.
They didn't give you a reason?
No, they said, can she go somewhere else, the 12-year-old?
I understand they're somewhat overwhelmed, but basically, that's why she went to live with her grandfather or stay with her grandfather?
Yes. So DCS was able to convince the mother to just let her go for the weekend and the son to the grandfather's. But then the mother stated that the grandfather's also abusive as well. So, it was in a bad situation, and I believe DCS should have came out, but they didn't find enough probable cause to come out fast enough, I guess.
All right,
Yes, sir.
thank you. Are we releasing him for?
Yes, Judge, thank
You
you.
may go about
Thank
your
you,
business.
officer.
Thank you, sir.
I would report to the court, Judge, as an officer of the court, that there is a DCS case that they're handling the Sophie mother situation. Judge, my
Is
next,
Sophie the child that was here in the courtroom?
that was here, yes, Judge, yes.
All right, call your next witness.
Miss Elizabeth Wires, she's also outside.
You'll come up, please, ma'am. Step right around here, and I'm going to ask you to raise your right hand and be placed under oath.
Good morning, Miss Elizabeth. Thank you for coming out today. Would you state your name for the record, please?
My name is Elizabeth Nicole Wires.
Okay. If you can speak up a little bit louder.
Yes, sorry,
You
my
can-
name is Elizabeth Nicole Wires.
Ms. Wiley, if you'll pull the base of that, grab a hold of the base of that thing, the very bottom. Now pull it towards you. There you go.
Perfect.
Thank you.
Okay. And so how are you related to the parties here today?
I'm not related to Amy, but I'm related to her daughter. So I am Sophie's cousin.
Okay. And so are you the sister of Sophie's father? Is that right?
Sophie's father is my uncle.
Sophie's father is your uncle. Okay. And so have you known Sophie and Miss Hewitt for a while now?
Yes,
How long
before,
have you known them?
so when Amy was pregnant with Sophie, That's when I first met her, and so I've known them Sophie's whole life.
Okay. And have you been around Ashton as well, the 4-year-old boy?
Yes, ma'am, off and on.
Off and on, okay. And have you been to Miss Hewitt's home?
Yes.
Okay. How often would you go there?
Not very often, maybe 2 or 3 times a year. It just depends on how often I see Sophie that year. Most of the time, I don't usually step inside her home. I usually just go to pick Sophie up.
Okay, so you would pick Sophie up to have some time with her, is that right?
Yes.
Okay. So did you maintain a relationship with Sophie?
Yes.
You and her have a good relationship?
Yes, ma'am.
Okay. Do you have phone calls as well?
Yes.
Okay. And so when was the last time that you went there to Miss Hewitt's home?
I don't know the exact date. I would say it was probably maybe 4 weeks ago, 3
Okay.
or 4 weeks ago.
Judge, if we could have Ms. Wires look at the photos that we entered into the exhibit. I'd like to, for you to take a look at those photos and see if you could identify them, if they're familiar to you.
Yes, they are.
Okay. Do you know who took those photos?
I took the photos of the bathroom, and then I had Sophie take the photos of the rest of the house.
Okay. And were those photos taken just within the past month here?
Yes.
In August? Okay.
Yes.
And so those photos, do they depict what you would usually see in Ms. Hewitt's home when you go there?
Yes, ma'am.
Pretty much for how long now? A year, 2 years, 3 years?
I can recall it was probably a couple years back when I delivered a vanity to Miss Hewitt's house for Sophie for Christmas, and the state of her home was still pretty close to this.
Okay.
So it's always been.
Been that way?
Yes,
Okay.
ma'am.
And so you had, did you have some concerns about Sophie's welfare here recently in August?
Yes.
Okay. Can you tell the court about what you know about Sophie's situation at Miss Hewitt's home?
I do know that her mother is very verbally abusive towards her. When I was on maternity leave, I talked to Sophie a lot on the phone, and Ashton was still in Amy's house at that time. And I recall her constantly yelling at Sophie, asking her to take care of Ashton, change Ashton's diapers, prepare food for him, do laundry, clean chores, some regular chores, but mostly asking Sophie to wait on her and Ashton.
Okay. And is this something that would happen whenever you're on a phone call with Sophie?
Yes.
And you would hear Miss Hewitt's voice,
Yes,
and
constantly.
you're sure that that's her
Yes.
talking to Sophie, commanding Sophie to take care of Ashton's needs. Is that right?
Yes.
Okay. Do you ever observe what type of foods that Sophie and Ashton would have at Miss Hewitt's home?
Yes.
And what are they?
So mostly takeout. I know they do DoorDash a lot, fast food. And then the last time that I was in her home, I observed mostly canned foods. They had like microwavable mac and cheese, pudding, nutritional shakes, those little applesauce packets, things of that nature. But no cooked food ever.
Okay. And so do you know anything about Sophie being on Adderall?
Yes, ma'am.
Okay. And do you know anything about anybody taking her Adderall?
Yes, ma'am.
And who would that be?
Sophie has told me on several occasions that Amy will take her prescription and actually take the prescription herself, and that she will sometimes give Sophie half of Amy's prescription instead.
And this is Sophie telling you all these things?
Yes, ma'am.
Okay. All right. And so you said you've been around Ashton. Do you have any observations of Ashton responding to Miss Hewitt, how, their relationship is?
I mean, their relationship seems, I guess, normal for his, he is delayed mentally. He seems excited to see her most of the time, but he is also agitated quite a bit. But I think that's just because of whatever mental issues he has.
Okay. Based on what, what you are aware of as far as Sophie is concerned, what is your opinion about Sophie living with her mom at this point?
My opinion?
Do you feel like she's safe there?
No,
What about Ashton?
no.
Those are all my questions, Judge.
All right, Ms. Hewitt, you have the right to, again, ask questions. You're not required to ask questions, but if you want to ask a question, you may do so. Do you wish to ask any questions?
No,
All
sir.
right, thank you, ma'am. You may step down. You may leave, or you may have a seat in the courtroom if you like.
Thank you, Ms. Wires. Appreciate it.
Ms. Hendrickson, you may call your next witness.
I'll call my client, Judge, Mr. Fenton.
Mr. Fenton, if you'll come up.
You state your name for the record, please.
Matthew Christopher Fenton.
Mr. Fenton, you heard Miss Hewitt tell the court in her opening that Ashton did not miss school to that effect. Is that right?
Yes.
When he was still here in Oakmont Elementary?
Yes.
Okay. I handed you documents. Do you recognize that document?
Yes, the school records.
Okay. And in fact, that has a business affidavit swearing that it is business record on the first page. Is that right?
Yes.
Okay.
Oak Pond Elementary.
Okay. So if you go over to this second page, does it state that Ashton had 17 unexcused absences between September 18, 2024 to January 23, 2025?
Yes.
Okay. Judge, I'd like to admit that as exhibit number 2.
Marked as Exhibit 2.
So it is not true that Ashton religiously attended school, correct?
Yes.
He had 17 unexcused absences, and that's just half of the year for last year, correct?
Yes. And we
Okay.
also had Thanksgiving and Christmas break in that period. So
Right. Okay. Now, who's your employer?
Colliers Engineering and Design,
Okay. And how much is your hourly rate?
$37.50,
Okay. So, and you work how many hours per week?
40 to 50, depending on the workload.
What is your routine? Is the overtime a regular thing for you?
Now it comes and goes.
It comes and goes. So would you say that 40 hours would be a correct number for your weekly hours that you put in?
Yes, ma'am.
Okay. So that amounts to about 6,000 a month. Is that right?
Yes, ma'am.
Okay. And as I've stated to the court, if there's a child support that will be awarded against or assessed against Ms. Hewitt, if the court allows our permanent parenting plan, are you agreeable to waive that child support?
Yes.
Are you able to provide for Ashton's needs?
Yes.
Okay. All right, so you became the primary residential parent January of this year, is that right?
Yes, ma'am.
Okay. And then since that time, so you transferred him from Oakmont Elementary School to where?
Allen County Primary Center, that's in Scottsville, Kentucky.
Okay. And immediately thereafter, he started school, is that right?
Yes, I think it was about 2 weeks. I had to get a birth certificate and social security card and all that stuff, and then I had to get him some shots, medical attention first. But
Okay.
I think it was about 2 weeks after I got him, mid-February.
Okay. And so you talked about the medical attention. Tell the courts, what have you done so far as Ashton's medical issues?
Well, we went to the cardiologist, primary care, the dentist, eye doctors. His eye would drift. And I've taken him to the eye doctor twice, just in about a 3 or 4 month period from when I got him in February, and then 3 or 4 months later, and his eyes are already correcting themselves. They used to just completely turn in, and now they're pretty straight. I'm not sure what the difference is and how it changed, but they were talking about surgery at first. So, and the last time I took him back, they said no, that he's made a lot of progress with his eyes.
Okay. Let's go back to the cardiology. Miss Hewitt has made a statement that she was in the process of changing cardiology. Didn't we find out that Ashton was supposed to have a November 2024 follow-up with Dr. Braun?
It wasn't with Dr. Bronze, but it was the same practice. It was Vanderbilt.
Right.
And I can't remember the other lady's name, the other doctor that he ended up seeing, but it was still the same practice when I took him in February.
Right. And so he was delayed because he didn't go until February. Is that right?
Yes, ma'am.
Okay. Supposedly it was November.
Yes. that's
Tell
right.
the court about the cardiology situation. Where is he at with that?
Well, before when Miss Hewitt had taken him 2 years prior to me taking him, they said his condition was mild. And when I took him back, they said that it had gotten a little bit worse, and it was mild to moderate. Instead of 2 year visits, they moved it up to every year.
Okay.
But it's a valve at the top of his heart did not form properly, and they said eventually he could have to have a heart surgery. But when the flap closes where it's not formed right, the blood leaks back down into his heart, and it's called the Epstein anomaly.
Okay. But currently, he does not have any restrictions as far as, physical activities and things of that nature. Is that right?
No, ma'am.
And he can play like a normal kid
That's correct.
and all those things. Okay. And then you said that you had gotten him caught up with the ophthalmology. Is that right?
Yes, ma'am.
Okay. Is he getting physical therapy?
Yes, he's getting all that through the school, kind of like the same as Oakmont. He gets physical therapy, speech therapy, occupational, everything that they provide.
Okay. And he doesn't have any unexcused absence thus far. Is that right?
No, ma'am. He didn't have any last year, and he doesn't have any current.
Okay. And he just started the fall semester, school year. Is that right?
Yes, on August the 20th was his first day back.
And how is he responding to the new environment? Tell the court about the school situation.
Well, he's doing really, really well. The teacher called me yesterday, and she was ecstatic, and she was like, yeah, she said, Matt, I had to call you. She said, I was showing pictures to the class, and I was asking them, what it was, and she said it was a picture of a school, and she said all the kids were screaming and yelling, and they were like, school, school, school. And she looked at Ashton, and she said, Ashton, do you know what that is? And he said, school. And that's the first words that she's ever heard him say. And then I asked him last night as well about it when I was sitting talking to him, and he said school for me. Day before yesterday, he was eating some M&Ms, and when he grabbed the yellow, when he said yellow, I mean, so his vocabulary's getting better. It's not any sentences put together or anything, but he'll tell you thank you. We have taught him sign language, please and thank you, and if he wants more or stop, little stuff.
Okay.
But Miss Rachel, that show helps a lot with it as well.
Great. And so he is beginning to get better with his speech. Is that right?
Yes,
Slowly, slowly but surely.
Yes, ma'am.
Okay. And is he gaining friends in the community?
Oh yeah. He has all the little kids in his class. I think there's 18 other students, and they love Ashton to death. And I took him on a field trip last year and got to see all of them interact. And
Okay. Did his social skills got better?
oh, very much so. His ability to walk and climb, and his feet used to turn in real bad. They still do a little bit, but they're straightening out. But he runs and jumps and plays, and I don't know. He's just like every other normal kid, I mean, besides not speaking. But he's very polite, and he's on a routine schedule. He usually wakes up around 6 to 6:30 on his own every morning, and he goes to bed at 8 every night. His schedule for his meals are the same time every day. Snack time's the same time every day. He eats very well now. When he first came to live at the home, he would only eat the macaroni microwave cups, and then that was basically it. He wouldn't eat anything. Anything you put in front of him, he didn't even know what cereal was. And now Ashton eats everything, especially if you're eating it. He wants some of it too.
Okay. And so you have established a routine for him, is that right?
Yes, ma'am.
And he's pretty much used to that routine,
Yes,
correct?
ma'am. That's correct.
Okay. All right. And so you talked about medical, you talked about the home life. Is he getting along with, who are you living with? I'm sorry, first. Who are you living with right now?
My fiance and her daughter be Asia Wilking and Elena Reimers. Elena's 16.
Okay. And how is he getting along with Asia?
Oh, he takes right to Asia. She's a very sweet and nice person, and she's fell in love with Ashton, and the same with him.
And does Asia help you with the day-to-day care for Ashton?
Yes, ma'am, very much so.
Okay. Would you look at those photos that I handed you? Do you recognize those photos?
Yes, ma'am.
You took them, right?
Yes, ma'am. Me or Asia, one of the two, or Elena.
And those photos show Ashton, his home life with you and the family. Is that right?
Yes, ma'am, that's correct.
Okay. Judge, I would like to enter those as an exhibit
Mark them Exhibit 3.
number 3. So is it fair to say that Ashton is well adjusted now in your home?
Yes,
Okay. Well adjusted with the school?
yes.
Okay. And what about, can't remember if I asked you, what about his relationship with Asia's daughter, Elena?
I don't know, he really, really took to Elena. That's like his best friend. He follows her around
Yeah.
everywhere.
How old is Elena?
16.
16 years old. And in fact, you've been with Miss Asia for how many years now?
4 years.
4 years. So Elena basically looks at you like her own father. Is that right?
That's correct.
Okay. And so, what are your concerns moving forward now that we're asking the court to make this permanent? Would you be comfortable with Ashton spending the night at Miss Hewitt's home?
I mean, no, not after the police report that I read, and the things that the officers told me, and the cleanliness. It's not clean at all, and it was like that when I was going down for supervised visitation. There was chemicals everywhere, borax spread across the floor, and Ashton was playing in it. I mean,
Did you raise concerns to Miss Hewitt about that at the time?
yes, I sent messages
Yeah.
telling her the safety concerns and the health concerns of having those chemicals around, and she didn't seem to care too much because it stayed that way.
Yeah. Now, you heard me tell the court the days that Miss Hewitt had the visitation. So I'm gonna go over that with you. So she visited February the 7th, is that right?
Yes, ma'am.
Okay. And then she visited February the 21st.
That's correct.
And those were the 2 days where she had refused to take Ashton back to you as ordered by the court. Is that
Yes,
right?
ma'am.
And she was found in criminal contempt at that point.
Yes.
Right? Okay. Following that, she did not visit for the month of March, correct?
No, ma'am. It was probably a 3 to 3.5 month gap before the next
We'll
visitation.
go over each month.
Sorry.
What about April? Did she visit in April?
No, ma'am.
Okay. What about in May? Did she visit in May? May 30?
Yeah, I think it was very end of May because our court date was May 14th, and she did end up coming to a visitation
Okay.
shortly after that court date.
Okay, and, okay. So she arrived at 6:30 instead of 4 o'clock that day, is that right?
Yes, she said that she didn't know that the time had changed from
Okay.
6 o'clock pickup to 4, and I told her that that would be fine. You know, it's 2.5 hour drive and fighting traffic, and I was understanding and letting go.
Sure. So, and then the next visitation was in June June 13, is that right?
Yes, ma'am.
Okay. So that's 4 visitations beginning February, correct?
Yes.
Okay. And then what about in July? Was there any visitation there?
No, ma'am, because the last one was last month.
The last one was August the 8th, is that right?
Yes, ma'am, that's
So-
correct.
Per my count, she visited 5 out of the 15 weekends that she could have had. Is that right?
Yes.
Okay. Have you been accommodating to Miss Hewitt's circumstances?
Yes, ma'am.
And, you know, each time she would ask for, you know, maybe I'll be late and things of that nature. Do you stay and wait for her?
Yes.
Okay. And has she continued to send you not so nice messages even then?
Not so, I mean, not as bad as what it was, but she's
Okay.
very demanding and gets upset when she doesn't get her way, even though she's not following the court order, you know, and I'm still trying to be very understanding for Ashton's sake and wanting to see his mother for sure, you know.
Right. And was there a day in May where she had told you that she's coming and that was not her day?
Yes, yes.
Okay.
She demanded that she was coming, that she hadn't got to see him, and it didn't matter if it was her weekend or not, that she should get to see him. And we
Okay.
had plans, of course, you know.
And that's against the court's order, is that right?
Yes, ma'am.
Okay, and so we have prepared an amended parenting plan, and I will show this to you.
Thank you.
Okay, and so we're asking that you continue to be the primary residential, right?
Yes.
And we have, because we're asking that for now, no overnight visits because of the concerns, we put 0 on moms, and then yours was 365, correct?
Yes.
Okay. And then for mom's day-to-day schedule, she would have Friday beginning at 5 to 8 p.m.
Yes.
And then Saturday and Sunday, 8 a.m. to 6 p.m.
Correct.
And are you asking the court that her residential time just take place within, is it Allen County there in
Yes, ma'am.
Allen County in Kentucky?
Yes.
Okay. And then, so this would apply to the day-to-day schedule, is that right?
Yes.
And then for the summertime, you would ask for 2 consecutive weeks, the first and second months of the summer.
Yes.
Okay. And then for transportation, you would ask that the mother pick up and return to you after her visitation
Correct.
to your residence. Okay. And you're asking the court to maintain the exclusive major decision-making on all the issues, correct?
Yes.
Okay. We have you down as your income as 6,000 there, okay? Is that right?
Yes, ma'am. That's correct.
And did we receive any documentation from Ms. Hewitt about her income
No, ma'am.
from her lawyer?
No, ma'am.
Okay. And so we're asking the court to adopt the regulation imputation, which is 2,995, correct?
Yes.
Okay. And when we plug that in the child support worksheet, it would obligate Ms. Hewitt to pay you $448 per month. Is that right?
Yes.
And if the court approves this, are you waiving that?
Yes, ma'am.
Okay, and I think I asked you that in the beginning. Apologize. Okay. And the reason for the deviation would be because of the travel that's imposed to Miss Hewitt, is that right?
Yes.
And you want to facilitate her visitation with Ashton?
Yes, ma'am.
Okay. And you're able to provide for Ashton's needs anyways with your own income, is that right?
Yes.
Okay. And you're going to continue to provide the insurance for Ashton, correct?
That's correct.
And you're asking to be able to claim him for tax purposes?
Yes.
Okay. And you, I believe that's the major components of that. I would ask that to be entered as an exhibit, Judge. And that has a child support worksheet as well, if that's,
Mark it as
Adopted.
Exhibit 4.
This part of it, Ellen, or did I get an extra page?
yeah, you keep that together and hand it to the clerk. I believe I went over all the issues. Do you have any other concerns about this parenting plan that you would like to tell the judge?
No, ma'am.
Okay, that's all the questions I have, Judge.
Ms. Hewitt, again, you have the right to ask questions. I'm going to give you the chance to testify. Do you have questions for this witness?
No.
Thank you, then. You may step down.
Judge, I would like to call Miss Hewitt.
Q, if you'll come around, please, raise your right hand, be placed under oath.
Ms. Hewitt, would you state your full name for the record, please?
Amy Suzanne Hewitt?
Okay. Did you take any medication today before you went to the court?
No,
Okay. Are you employed?
no, I'm disabled.
You're disabled. Have you been found disabled by the government?
Since my first brain surgery in 2014.
So are you getting disability benefit?
Well, I've missed my recertification when I moved, and we're fighting appeals right now, so I haven't gotten it back yet.
So essentially, you're not getting any disability.
No, not right now.
How much was it before?
It was $986 a month.
96?
$986 a month.
986 a month. And when was the last time that you had gotten that money?
It's been 2 years now.
2 years, okay. All right. Do you have a lawyer assisting you on that?
No, ma'am.
Okay. And you said you had missed your recertification?
My recertification went to my stepmom's house, so she doesn't check her mailbox because she has a PO box. So she didn't know it was in there till months later.
Okay. Do you know your percentage of disability?
Do what?
Do you know the percentage of disability? Do you have that, say 50% disabled? I'm not familiar with it, so I don't know if they assign a percentage.
I don't.
Is there a percentage?
I
Do you
don't
know? Okay, that's
know.
okay. All right. What are other source? So you're not getting that. So what is your source of income? You said you're not employed.
No, I'm low income, single disabled mom. I get food stamps and Families First and child support from Sophie's dad.
Okay. How much is the family? I missed the word next to
First,
that. First, yeah.
It's $288.
Okay. And then how much
A
do you
month.
get for Sophie's? And that's a month. Okay.
Yeah.
How much is Sophie's child support?
Hers, I've never modified it. It's $156 a week.
Per week. Okay. Do you have any other sources of monies that come to you?
No.
Okay. And what was your previous employment?
I was a loan processor for a mortgage company.
Okay.
And then also I was a retail manager at the Children's Place at Bellevue Mall before the
Yeah,
mall
in
closed.
Bellevue.
Mhm.
Okay. And then when were you, I'm sorry, I forgot to ask, when were you first declared to be disabled?
It was, well, May 30th of 2014.
Okay. And then you lost it 2 years ago.
Yes, ma'am.
Gotcha. Okay. Are you getting any more disability payments as to Sophie
No,
for autism or things of
No.
that nature? What about Ashton?
no.
Okay. All right. And so you are taking Adderall, is that right?
I'm prescribed and
You're
have been-
prescribed?
Yes.
What type of Adderall? Is it the long acting or
It's-
fast acting?
It's one long acting, one short acting.
And for what? What was your
For
diagnosis?
attention deficit disorder.
Okay. Isn't it true that you're giving some of yours to Sophie?
No, ma'am.
Okay. Are you
No.
taking some of Sophie's Adderall?
No, I haven't even gotten hers filled. And I made her an appointment to get hers filled right before school started.
Okay. So when you get that filled, are you going to take hers?
No, and never
Okay.
have, never
So was
will.
she lying to the police when she reported that to
Yes,
them?
and she's admitted it.
She admitted it when?
She's admitted it and apologized and cried. She's not been
Okay.
right since Ashton's been gone.
She admitted it to who?
She admitted it to me, my sister.
Okay. Is there a DCS ongoing investigation?
There's nothing with Ashton, but with Sophie, I'm working with them, and I took her and we did a hair follicle test,
Okay.
and they followed up. They came back by, welcomed him in, they okayed everything, and Ashton was supposed to come back home that day from my dad's, and Sophie was supposed to it was up to me to let her cool off, and I was like, that's fine.
There is an open DCS case right now, correct?
With Sophie,
With Sophie.
yes.
And you're working the services, is that right?
And I'm working in counseling,
Okay.
everything.
So you needed counseling too, is that right?
No,
As you testified?
I'm testifying that they asked if I would do family counseling, if I would agree, and I said, yes, I'd do anything.
Okay, so they asked you and they did not tell you to do it?
They didn't tell me to do it.
Okay. All right. How's your driver's license? Do you have a court date in October, is that right?
Yes.
Okay. And that's been going on for about a year now, right?
Yeah,
And
because
you
I
haven't
can't-
resolved that?
I can't get to Nashville for some reason in Dixon, you can't get it reinstatement. And I don't have like family or anybody that can that's why it's so hard to get to Ashton. Like I would never want to lose my visitation or seeing him, but I don't have anybody or any way to get to Kentucky or even Nashville.
Okay, so, and that was suspended because you were driving under a suspended license, is that right?
I didn't have insurance.
You didn't have insurance, okay. And you're sure about that? That was not suspended at the time that you were charged with a suspended, this general sessions court case?
I know it all started because I didn't have insurance.
Okay. Do you have an attorney for that case?
No, I can't afford an attorney.
Okay. Did you bring any proof of income today?
No, I don't.
Okay. And you haven't given me any discovery responses from all the requests that I sent you, my office sent you, correct?
Once I saved all that money up for that attorney, I didn't know. I was told you were sent whatever was asked for. So I don't know.
Okay. Did you bring anything with you today in response to those discovery requests that I sent you?
I mean, no, I don't even know what is on there besides, I mean, I know you just asked about my income, but I mean, I live in low-income housing.
Okay, I'm just asking if you had brought anything. So you have nothing today to show the judge about, I sent you those photos that I was planning to put forward today. So you have nothing to show the judge about the condition of your home today?
Well, I'm not allowed to bring in my phone. So I couldn't show pictures. I didn't have time to print them out.
Okay, that's all the questions I have, Judge.
All right. Do you have any other witnesses?
No, Judge, it's our proof.
Ms. Hewitt, Mr. Fenton has rested his proof, so this is your opportunity to present whatever testimony you want to tell me about this situation. What today is about is for me to adopt a permanent parenting plan. That means ending this case and allowing, although it's always open for reopening, it's always available for reopening if a change of circumstances occur, but the order I put down today will terminate this pending litigation. So this is your opportunity to tell me what you want to see happen regarding your son, and that's the only thing that I'm considering is a permanent plan for how you visit with your son, or who's going to be the primary residential parent and so forth. So if there's anything you want to talk to me about or tell me about, I'm going to take a recess. It's time for our mid-morning recess, and then I'll give you a chance when we come back to present whatever proof you want, okay?
Yes, sir.
You want to testify anything else? Will you come on back up to the stand, please? Do you, I mean, you're not required to. If you wish to testify, I'll give you a chance.
Not sure what to do. I wish that this is in juvenile court where I think it should be, and I have evidence that would be admissible there that
Well, I'm not dealing with Sophie in that
I'm
situation.
talking about with Ashton.
Pardon?
I'm talking about with Ashton.
Okay. Well, if you want to testify, then you have to come back to the witness stand. If you don't want to testify about anything else, that's your option. And then I'll make my ruling based on the record in this case and what's been presented. You understand that? All right, then we'll proceed with this. Ms. Hendrickson, is there any other rebuttal proof you wish to offer? All right, I don't need any argument in this case. Court is well familiar with the facts and background of this situation, and as a matter of course, I am, in this particular hearing, required to make a determination about the permanent parenting plan that is to be adopted by the court. And in doing so, I'm required to follow the factors and consider the factors that are set forth in 36-6106 of the Tennessee Code. And those factors include the following: the strength, nature, and stability of the child's relationship with each parent, including whether one parent has performed the majority of parenting responsibilities relating to the daily needs of the child. This is a somewhat unusual case in that in the early years of this child's life, the mother was clearly the primary caregiver for the child, based on the fact that Father, Mr. Fenton, was not even aware that he was the biological father. Based on the statements that had been made to him by Ms. Hewitt, he was not aware that he was the biological father, and as a result, he was not involved in the child's life in the early years. And as that factor may apply, it would apply to her as being the primary residential parent, the primary parent for the child's early life. But once Mr. Fenton became involved, that situation somewhat changed. At prior hearings in this court, the court considered and relied upon the statements that Ms. Hewitt made regarding this child's physical limitations and special needs, and limited Mr. Fenton's initial visitation with the child based on the fact that the court has always tried to err on the side of protecting the child's best interest. And someone who's unfamiliar with the child suddenly becomes in the child's life, then I have to consider how that impacts the child. So that was the reason that Mr. Fenton was granted some limited visitation to begin with the idea that it grew the relationship between Mr. Fenton and the child. As this situation progressed and future hearings were conducted, the court unfortunately determined that Ms. Hewitt was less than candid and truthful with the court regarding the child's physical and physical needs, health care needs, and the special needs that this child has, and the steps that she had been taking to try to ensure that the child was receiving the type of care. It became readily apparent to this court that Mr. Fenton had done his homework and had checked into and became much more aware of this child's needs and found out that the child's needs were not being met. And for that reason, the court, and we also viewed a video that had been transferred, that had been videotaped during a transfer of custody, wherein Ms. Hewitt demonstrated a behavior at that time that this court found to be unacceptable regarding the best interest of the minor child. So at that point, the court believed that it was in the best interest of the minor child to transfer the custody temporarily and make him the primary residential parent. Everything that I have heard since that time has convinced me that that was the appropriate step, that was the appropriate thing to do. So considering the strength, nature, and stability of the child's relationship with Mr. Fenton versus Mrs. Hewitt, since he has been made the primary residential parent, I clearly find that Mr. Fenton's relationship with this child is much more stable, it is stronger, it is more caring and protective of the child and ensuring that this child's needs are being met than the relationship that Ms. Hewitt has had now under the limitations that she has with the weekend visitation, or even in the past because of the fact that testimony has been that she has been somewhat verbally abusive towards this child, according to the testimony before the court. So factor number one of that code section clearly applies in favor of the father. Each parent or caregiver's past or potential future performance of parenting responsibilities, including the willingness and ability of each of the parents and caregivers to facilitate and encourage a close and continuing parent-child relationship between the child and the other parents. This factor, again, clearly favors the father in this case because Mrs. Hewitt, both in her testimony in the past and her actions, has made it clear, abundantly clear, that she wishes that she had never even sought child support for the child because that's what led to Mr. Fenton being involved in the child, and she would rather have kept him completely out of the child's life, as she did in the past, rather than let him have a relationship that he now has. So I find that is that clearly Mr. Fenton, who wants to have a relationship with his son and who wants her to have a relationship with the son, I think that factor, again, favors the father. I don't have any indication that Mrs. Hewitt or Ms. Hewitt or Mr. Fenton have either one actually attended the court-ordered parent education seminar, but they're both going to have to submit proof of that within 60 days, I think is what the parenting plan says. The disposition of each parent to provide the child with food, clothing, medical care, education, and other necessary care. Part of my concern and part of the reason that I relied upon, the reasons that I relied upon in making the change of a temporary custody to Mr. Fenton was the fact that I felt that Ms. Hewitt was not providing this child with the type of medical care that the child needed. This child's medical needs were not being addressed. The cardiologist's appointments were not being kept. Mr. Fenton has stepped in and he has, in a very short order, gotten this child back on track with all of the care with an ophthalmologist as far as the child's eyesight, and has improved the eyesight greatly of this child according to the testimony. He's improved the speech of this child. child is now speaking some words, even though he had been borderline nonverbal. He is now on track with his cardiologist. He clearly has a significant heart issue that must be addressed and must be watched and monitored. I know this because I have a cousin. When I was a young child, my cousin, who was 10 or 11 years old, had a hole in her heart, and she had surgery, and she died on the operating table. So I'm well aware of the fact that a heart issue with a minor child can be very, very concerning and very, very serious and needs to be dealt with. So the fact that Mr. Fenton has stepped in and in short order has gotten this child on a right track to improve his education and speech, his health, and and his eyesight and everything else, clearly, again, affirms that this was the right decision to have been made, and that factor clearly favors him. It is also, unregrettably, a fact that this court finds that Mrs. Hewitt had disability according to the testimony and let that disability expire because she did not get a confirmation, a reconfirmation, a reaffirmation of her ability to have that. If you are disabled, then that's one of the most important things you can do, because if you're saying you're not able to work, then you're going to have some way to support yourself and your child. There is as this court is well aware, a Social Security disability also provides a benefit for the children. And if, in fact, this order will contain a provision that if, in fact, Ms. Hewitt is again placed back on the disability status with the Social Security Administration, that portion that would be payable for this child will be paid to Mr. Fenton, because clearly I'm headed in the direction of making him the permanent parent, primary residential parent, but that benefit will go to him and not to her. So it needs to be sure that that is in this order so that it can be sent to the administration, Social Security Administration. The court is also aware on this factor of the photographs and the testimony of the police officer regarding the conditions that were existing at the time in Miss Hewitt's apartment or house that she was living in. And frankly, those conditions are unacceptable for any child to have to live in that kind of filthy environment. And the chemicals that were there on the floor in those photographs within easy reach of this young child who has disabilities is, again, unacceptable. And we're just lucky that it hasn't had a tragedy taken place. Number 5 of these factors is the degree to which each parent has been a primary caregiver. I've addressed that. And currently, Mr. Fenton is clearly the primary parent providing the care for the child, and he's taken the greater responsibility for performing all parental responsibilities. Number 6, the love, affection, and emotional ties existing between each parent and the child. Mr. Fenton didn't have a chance to bond with his child until he began his visitation. But the photographs that have been demonstrated here today of his interaction with his son, the statements that have been, the testimony that's been offered regarding his relationship with his son, clearly established that there was a strong bond between him and the child. And Mr. Fenton has, as a mature father, I don't even know how old he is, but clearly he's not a young man by some standards. He is young by my standards, but he has taken it upon himself to parent this child, and I think there's a strong bond between them. I don't doubt that Ms. Hewitt has love and affection for her son, but the testimony has been of the verbal abuse that she heaps on this child for something that he does or does not do, the neglect that it appears to me that this child has been subjected to, make it obviously clear that this is a factor that would benefit, that would favor Mr. Fenton. Being a parent is more than having biology. It's more than being able to have a child. You can birth a child, you can be a father to a child, but that's not being a parent. Being a parent is addressing the child's needs and putting that child's needs ahead of your own needs. And I think Mr. Fenton has shown an admirable willingness to upend his life at this stage in his life to become a parent of a young child with needs. And Mrs. Hewitt, in my opinion, has failed to show that she is willing to put this child's needs first in her life. And as a result, I find that factor to favor the father. The emotional needs and developmental level of the child, I've touched on it, but I'll touch on it again. This clearly is a factor that favors Mr. Fenton because there are developmental level needs of this child that Mr. Fenton is addressing that have not been addressed. 17 unexcused absences from a year of school for a child that has special needs is unacceptable. Mr. Fenton has been able to enroll the child in school and make sure that the child is there every day. There are no unexcused absences according to proof, so therefore it clearly shows that he is addressing the developmental needs of this child. All of the other steps I've referred to, the medical care, the eyesight, working with the school regarding the child's speech, all of those things have been things that have occurred since Mr. Fenton became the primary residential parent, and they will continue to benefit this child in this court's opinion. And they were not being met in this court's opinion while the child primarily resided with Ms. Hewitt. The moral, physical, mental, and emotional fitness of each parent as it relates to their ability to parent the child. The court has watched and has observed these two parties, and there is a marked difference between them. When this case first became before the court, my opinion of Ms. Hewitt was that she was forthright, she was forceful in her testimony, and I thought at that point it was credible, and that just goes to show you sometimes the court even is mistaken about these things. I have learned that her testimony previously has been filled with inaccuracies. That to charitably call them an inaccuracy would be one thing. The other thing would say that she committed perjury when she testified in this court. But in any event, the court is of the opinion that Mr. Fenton has not demonstrated, and he is here today despite the fact that, and subjected himself in the past to testimony, even just in the fact that there have been some false allegations made against him in the past that came out in a prior hearing, and those things have been completely proven to be untruthful and unmerited. And the fact of the matter is that was something that Ms. Hewitt attempted to use against him, and those things, this court is of the opinion, again, demonstrate the difference between these two is marked. I don't find that the testimony of Ms. Hewitt today and her demeanor in court demonstrate to me that she is either emotionally fit to have the primary care of this child or not. The use of Adderall is a drug that can have great benefit to people who have a demonstrated need for it. It is a drug that is often abused by people who have a drug issue, and the use of Adderall has been testified here today concerns this court greatly regarding whether or not Ms. Hewitt is actually using this drug in the way that it was intended to, or if there is a demonstrated need for Adderall. Too many people use Adderall just as a substitute for other types of drugs, and it is this court's opinion that that is a factor that must weigh on the physical and mental and emotional fitness of Ms. Hewitt. Child's interactions and relationships with other siblings. Obviously, the court has heard testimony regarding Sophie, the child that Ms. Hewitt has, that is still in this situation. I don't know whether that situation will change based on the Department of Children's Services. This court doesn't have the power to make certain parents good parents. I wish I did. I wish I could wave a magic wand and, things would be different for Sophie growing up. But the fact of the matter is that Ms. Hewitt is the biological mother of Sophie, and she, at this point, has care and custody, and Sophie, unless the Department of Children's Services steps in, will have to live in that conditions that I see in those photographs. So that's really regrettable for this child. One of the reasons I wanted this child to be outside of this courtroom is if she has to live with Miss Hewitt, then under those circumstances, I did not feel like it was appropriate for Sophie to have to listen to some of the things that were being said about her mother. You know, she may find it out later, and that's up to them as to whether that happens. But another factor that the court considers is Ms. Hewitt's statement that Sophie, who made these statements regarding the use of the Adderall, or her Adderall and so forth, to the investigating officers and other people, that she suddenly confesses to her mother and to her mother's sister that she was lying about that. Well, that's typical of a scenario where a child is recanting a testimony when they're found that they are still having to live with the person who is doing something that's inappropriate. The importance of continuity in the child's life, this court finds that that favors the father, that clearly the stability that Mr. Fenton has offered this child is in this child's best interest. The evidence of a physical or emotional abuse to the child, the court is of the opinion that, as I've stated, the testimony regarding the verbal abuse towards this child is a factor that goes against the mother and favors the father. The physical abuse can also be attributed in some regards to the neglect that has occurred while in Miss Hewitt's custody. The character and behavior of any other person who resides or frequents the home of the parent and the person's interaction with the child. There's no testimony regarding that about any of the other parties. The reasonable preference of the child of 12 years doesn't apply. Each parent's employment schedule, Mr. Fenton is the only one employed, and as his testimony is he works a 40-hour week average, which is fairly standard, and he has other folks who are able to assist him, his fiance and her daughter who live with him. So there's no problem with his work schedule. Any other factors deemed relevant by the court, and this court is of the opinion that too often we see people who portray themselves as a victim in a particular situation. And I don't mean to be unduly harsh to Ms. Hewitt, but it is this court's opinion, having observed her demeanor and behavior and testimony in prior hearings, that she has very much been willing to portray herself as the victim in the situation. And I think she still continues to portray herself in the role of the victim. As a result of that, I don't find that she is the victim of anything other than her own malfeasance, her own bad parenting towards this child and towards Sophie, and that as a result of that, this court does not consider her to be a victim of in any way, shape, form, or fashion, but I do believe that she is willing to portray herself in that way as an effort to try to convince the court that she has been victimized by this procedure. So, based upon all of those factors, this court finds that a clear and convincing, even though that's not the standard, the clear and convincing evidence in this case is that Mr. Fenton is should be, and it will be made, the permanent primary residential parent of this child. And as far as this court is concerned, I have considered the permanent parenting plan that he has proposed, and this court adopts that proposed parenting plan in its entirety. Part of the reason for that is because when I granted Ms. Hewitt the visitation, there were multiple instances that she didn't visit with the child, or multiple instances where she failed. She would come pick the child up and then say, I can't bring him back. And that is playing games with the court's orders and this court's opinion. Right now, based on the circumstances that I've heard today, the conditions existing in her home, it is inappropriate for her to have overnight visitation here in Dixon County, and therefore her visitation will be set in the county wherein Mr. Fenton resides, and it will not be supervised, but it will be according to the schedule that is set out there and then it will be incumbent upon her to visit with the child there. Now, the parties can agree at any point to a different schedule, Mr. Fenton. If she's up there for the weekend and can, or up there for the day and can spend the day with the child there in that county, but I am ordering that her visitation at present be exercised in the county where you reside, not bringing the child back and forth. And every other aspect of this proposed parenting plan the court will adopt. The child support issue, at this point, Mrs. Hewitt is not employed. I don't have any real evidence before me to say that she couldn't be employed, but she is not. And Mr. Fenton is willing to waive child support at present. I'm not waiving it, I'm simply reserving it. And that means that if she becomes employed, then this issue can be revisited. If she becomes disabled or gets her Social Security disability reinstated, as I've stated, then that benefit for the child will go to Mr. Fenton. But the issue of child support, she might play the lottery and win that $1 billion lottery. In that case, she's going to need to pay her fair share of child support. That's why I'm reserving it and not just waiving it. So it'll be reserved and it'll be there in the event the circumstances change to where it could be done. Now, I've spoken fairly harshly about you, Ms. Hewitt. I would like nothing more than for you to get your life straightened out, get back on a kind of a relationship that you could have with your child. But right now, I don't find that you are the proper parent to have the custody of this child, and that there are issues in your life that you need to address. Get those issues resolved, get your life straightened out. You will have the right to come back to court and petition the court for a modification of your visitation, but it will require a material change of circumstances. And so you're going to have to prove when you come back to court that things are better for you and that you can actually exercise visitation that will be in the best interest of this child. That is the judgment of the court. Miss, you may.
So I heard you say that you're adopting the parenting plan. Would that include the imputation of Ms. Hewitt's income there per the regulation? Or although it will be zero at the end of the day because of the deviation that I included there.
You need to show that there's a deviation because she is
Yeah.
unemployed.
So
And-
Judge, I'm just concerned about if we use the word reserved, it's not in conjunction with, we deviated, but then we also say the child support is reserved. Can we say that?
I am not considering your calculation of child support because that was based on an imputation of income to someone who is not working and who says she was on disability.
Okay.
I am instead simply reserving the issue of child support so that in the future, if she becomes employed, it can be revisited.
Okay, so however I drafted it, I'll keep it that way. Is that right?
That's correct.
Thank you, Judge.
All right. Then that concludes this hearing, and this concludes this matter will no longer be pending before the court with the entry of this order. Therefore, we are adjourned.